Good afternoon and welcome to the Society for the Rule of Law's webinar on contemporary threats against free speech in the United States. My name is Gregg Nunziata and I am the Executive Director for the Society for the Rule of Law, and I'm delighted to have this panel with us today and for our audience. It's an important conversation and I am eager to dive into it, but if you'll allow me just a few preliminary introductory remarks. The Society for the Rule of Law, if you are not familiar with us, is an organization of primarily lawyers, right of center lawyers, libertarians and conservative center-right folks who prioritize the defense of the Constitution, the rule of law, and American democracy above our policy or partisan preferences. We do our work through some targeted advocacy and lots of education and discussion like the one we're about to have today. We are a membership organization. Our members make our work possible. So if you're interested in what we do, if you enjoy this program and you're not a member, please consider joining. We'll have a link in the chat to our membership page. There's membership at various levels. You do not need to be a lawyer to join. Thank you for considering that. Just updates on society news and events. There are a lot of updates this week. We've done a lot just in the last few days. The Society joined the Society for the Rule of Law Institute, joined a coalition of groups, including FIRE, from which we have a speaker today, on an amicus brief concerning the executive orders against a law firm. That's our third in a series of such briefs. We also sent a letter to the Senate Judiciary Committee opposing the confirmation of Ed Martin to serve as U.S. Attorney in the District of Columbia. Just yesterday, we partnered with the State Democracy Defenders Fund in supporting a group of over 150 retired judges, conservatives and liberals, who wrote a letter to the Attorney General opposing efforts to delegitimize or intimidate the federal judiciary. Many society leaders and members appeared in the media just this last week: 60 Minutes, MSNBC, Washington Post, The Hill, The Atlantic, and more. There are links to all those appearances and op-eds on our website. On our programming, next week, we'll have a live event in Phoenix, Arizona. I will be interviewing Justice Clint Volokh of the Arizona Supreme Court about the independence of the judiciary and the rule of law. The next day, I'll be speaking at the American Democracy Summit, also in Phoenix. The following week, May 20th, our board president, George Conway, will be debating those executive orders against law firms at a Federalist Society event in New York City. We'll have links to all those events and more on our website and in the chat. Please give a look and consider joining us. There'll be more webinars soon too, so look for announcements. And with that, let's get to our program. I want to leave as much time as we can for Q&A, and I invite the audience to submit questions in the chat. You don't have to wait till Q&A. I will keep an eye on it. Please try to keep them brief so we get to as many as possible. And with that, allow me to introduce our very distinguished panel on this issue. Professor Keith Whittington is a professor at Yale Law School, where he focuses on constitutional history, the presidency, and free speech and the law. He's also a charter member of the Society for the Rule of Law, and we're happy to have him amongst us. Last year, he co-wrote a relevant book called You Can't Teach That, about academic freedom. We did a book talk on that here at the Society. There's a link to that in the chat as well. You can go back and learn more at depth about that issue from Keith. Mr. Bob Corn-Revere is the chief counsel at FIRE, the Foundation for Individual Rights and Expression, which is a free speech and civil liberties organization. Previously to joining FIRE, he was a partner with the law firm of Davis Wright Tremaine. He also served as chief counsel to the FCC and has some interesting things to say and perspectives on the role of the FCC today. Finally, we will conclude with comments from Professor Eugene Volokh, who is the Schwartz Professor of Law Emeritus at UCLA and currently at the Hoover Institute at Stanford University. With that, let's dive into our conversation. I think Professor Whittington will open us up. This should be an interesting, very relevant conversation. We're in the early days of an administration that actually kind of campaigned on the principle that they would bring free speech back. So how is it going, Professor Whittington?
Thank you. I'm glad to be included in this conversation. It's an important conversation at this juncture. I'm sure we will have lots of exciting things to talk about over the next 3.5 years or so of this administration as well. So it's interesting that you start by mentioning that the Trump campaign in part emphasized the idea that they were going to be a free speech administration and help bring free speech back to the public sphere. That's an encouraging aspiration in that I think we had some real free speech challenges, and I certainly was not happy with some of both societal and cultural activity that was occurring in the free speech space over the last several years, and some specific things with the Biden administration relative to that. Unfortunately, I don't think there's much evidence that the Trump administration is actually trying to set itself up as in any way, shape, or form advancing free speech in general. There's not much in terms of their initiatives that I think is particularly free speech friendly, let alone free speech encouraging, particularly, and an awful lot that they're doing that is very hostile to free speech, no matter how you might try to understand it. Rather than trying to walk through some of the details, which I'm sure we'll get back to, of sort of specific actions or policies the administration has already undertaken, or players within the administration have already undertaken at this stage, I thought I would just highlight sort of the issue that there are sort of different buckets that we might think about these activities of the administration falling into in this regard from a free speech perspective, which is often true, I think, when we're talking about the free speech space. That is to say, sometimes there are things the government's doing that run afoul of actual legal restrictions of First Amendment doctrine relative to constraints imposed on government actors and what they can reasonably do in using their governmental power that might impinge on or restrict speech in various ways. And you would hope that courts would be willing to intervene to enforce those constitutional boundaries in some of those cases relative to some of those policies. And we're seeing the administration doing some of that, that they're engaging in some activities that I think just run afoul of existing constitutional doctrine or are just unlawful from that perspective. But there's a whole nother category that I think for those who care about free speech more generally ought to be interested in, which is not just what's consistent and compatible with the law and what does the First Amendment allow, but also what kinds of things are compatible with a free speech culture more generally. And it's, I think, also true that the administration is not only doing things that are probably illegal and unconstitutional in various ways, but they're also doing a lot of things that are just incompatible with a free speech culture, broadly understood. And some of that is dancing around areas where there are genuine legal ambiguities and uncertainties about what the scope of the law is. Some of these are spaces where they're probably operating in areas in which there is actually a lot of lawful authority for the administration to do. And yet, nonetheless, it's clear that part of what the administration is interested in trying to do through its activities across a whole range of fronts is to suppress as much dissenting activity as possible, to suppress dissenting voices, to discourage and chill dissenting voices through their activities in general. And even when they are operating consistent with the law, nonetheless, they can be acting in ways that are quite incompatible with allowing and fostering a independent civil society that's willing to challenge and question what the administration is doing in general. So just to highlight some of those areas where I think, for example, where there are ambiguities at the very least about sort of what the scope of legal authority is. We might think about the sort of scope of free speech rights of resident aliens in the country, for example. This remains unclear under the scope of constitutional law. I think there's good arguments to say there's a lot of First Amendment protections for resident aliens in the country in general, but exactly where the boundaries that are, I think, are not always entirely clear under existing law. I think the administration has pushed way past anything that I think is very viable as a set of understandings about what the First Amendment ought to require in this space. But clearly the goal is to try to broadly discourage foreign nationals who are inside the United States from criticizing the administration or engaging in political speech to the administration finds unacceptable in some fashion or another. You mentioned Ed Martin, for example, and among the activities he's engaged in already from his post is sending threatening letters to various academic entities demanding answers as to why they're engaging in the kind of speech activities they engage in, whether it's scientific journals or Georgetown University Law Center, for example. Some of that we might characterize as so-called jawboning, as the administration or administration officials simply encouraging private actors to do things that they find better, but not actually coercing them in order to undertake certain kinds of actions. But I think it's clear that those letters are designed to be chilling. They're designed to be intimidating. They're designed to discourage private actors from continuing to engage in the speech activities they might otherwise engage in. And they're doing it in ways that Ed Martin has no reasonable role or authority to engage in. So the administration, I think, is pressing on private dissent across a wide range of fronts, and they're using lots of different kinds of tools to do it. Some of which we might hope that courts are going to be able to check and restrict. But some, I think, we may find that courts are just not well positioned to react to because they're operating within these ambiguities or operating within space that they legitimately have. And yet, nonetheless, the consequences are not good for a free speech culture.
Excellent. Thank you, Professor Whittington. Let's go next to Bob. Bob Corn-Revere, I mentioned, is a litigator. He's involved on many fronts in these discussions and battles. He has a couple of great recent pieces on what's going on at the Federal Communications Commission right now. We'll drop links in the chat to that. But I invite Bob to speak about those issues or any of the other matters he's engaged in. Please, Bob. Thank you.
Well, thanks, Greg, for including me in this conversation, and particularly among this group of really phenomenal speakers. I'd like to start with sort of your opening premise, talking about the promise of the Trump administration, because certainly there were abuses in the previous administration that a number of us pushed back against. And one of those was the inspiration for one of the first executive orders that came out, one that was designed to, as the title of it said, restore freedom of speech and ending federal censorship. And it talked about in its opening statement the fact that the Biden administration had tried to suppress, quote, misinformation by leaning and imposing official pressure on various social media platforms, that led to changes in their editorial practices and moderation policies, and that had to end. And the executive order said in no uncertain terms that government censorship of speech is intolerable in a free society, something that I think we all agree with. And then it went on to adopt the official policy of the United States not to let any members of the administration restrict speech, and that it would direct the Attorney General to look into that. But then it sort of took an unfortunate turn, saying that it's going to look only at the activities of the past 4 years to make sure that people in the past didn't restrict speech. It didn't have much to say about what might happen in this administration on suppressing speech. And then, as sort of a kicker, the final paragraph of the executive order, and you'll find this sort of uniform throughout the orders that President Trump has issued, is to say that this executive order creates no rights in any individual to hold the government to account for this statement of policy that the government shouldn't be involved in censorship. And so I think if you look across the range of executive actions, you find that there is a lot of irony here after this sort of overarching statement that the government should not be engaging in censorship. You have any number of things. Greg, you mentioned at first the executive orders targeting law firms. That's one dimension of it. Actions based on suppressing any discussion or programs on DEI. And, certainly there have been problems with DEI going too far, where Fire has, among others, been involved in pushback on that. And yet here we have an administration that is bent on crushing anyone's ability to have DEI programs or to have discussions of it. You have executive orders that have targeted individuals, and in particular, two individuals who previously served in the first Trump administration. You have the actions against the Associated Press for the reason that this international news organization didn't change its style book to conform to the president's preferred title for the Gulf of Mexico, now the Gulf of America. And then you have other actions like the Justice Department revising the internal guidelines on when it might issue subpoenas for news organizations in leak investigations or others. So you have a whole range of activities that are going on. So it does create a bit of a challenge in narrowing it down. Now, Gregg, you mentioned that I used to work at the FCC, so I'll try and focus on that for just a limited time. And even just looking at that one aspect of this administration, there is really more to talk about than there really is time during this session. This is combined with sort of the White House takeover of independent regulatory agencies. There was a February 18th executive order that essentially said that all executive departments, including, quote, independent regulatory agencies, have to funnel all of their actions through the White House, meaning that any vestige of independence by agencies like the Federal Communications Commission or the Federal Trade Commission are now official arms of the White House. That represents quite a bold move in terms of expanding executive authority over these independent agencies. But as it turns out, if you have compliant chairs in place in those agencies, it really doesn't matter if it's done officially or just really as a matter of political understanding. And that's been the case with the Federal Communications Commission, where one of the first acts after the inauguration was to name Brendan Carr as chairman of the FCC. He had been a commissioner there since 2017, but in coming to the agency was fully on board with the administration's agenda, which was not necessarily a free speech friendly agenda. Chairman Carr had been the author of the chapter on the Federal Communications Commission in Project 2025, and he wasted no time upon assuming the chairmanship of using the power of the chairman to put pressure on perceived political enemies and of press organizations from that role. And actually, even before he was officially named chair, between the election and the inauguration, he was already sending threatening letters to heads of tech companies, for example, talking about how they shouldn't be involved in moderation practices, or a letter to ABC criticizing the network, both for its news coverage and for its relations with its affiliates. And he was pretty widely quoted on social media and elsewhere saying that broadcast licenses are not sacred cows, that he's going to hold broadcasters to their public interest responsibilities as he sees them, and a very muscular view toward regulating speech, contrary to what we've seen from previous administrations and certainly from previous Republican administrations. If you recall back to the 1980s, it was under Ronald Reagan that Chairman Mark Fowler repealed the Fairness Doctrine, which gave the FCC a measure of control over news organizations. And the commission concluded at the time that that was incompatible with the First Amendment and didn't serve the public interest. And yet now we see an FCC very determined to use that authority, or that perceived authority, to regulate broadcasters. And this began immediately after Chairman Carr ascended to the chairmanship. He rescinded dismissals of complaints against broadcasters, in many cases politically motivated complaints, that had been dismissed right before the inauguration, and put those complaints back in place. One was against ABC because the moderator of the presidential debate had fact-checked then candidate Trump, against NBC because of an appearance by Kamala Harris on Saturday Night Live in an apparent violation of the FCC's equal time rules, even though NBC at the time offered, and the offer was accepted, for Trump to appear on another NBC program, and one which actually had more viewership. And then most notably against CBS, because there was a complaint that the 60 Minutes interview with Kamala Harris right before the election had been modified in that they didn't provide the complete answer. That was filed as a news distortion complaint. That was restored, and even supercharged in the fact that the agency not only continued the investigation into CBS, but then opened a public proceeding to receive public comment on whether or not CBS had violated its news distortion rules. Now, it's important to pause for a second to realize how remarkable that is. The FCC may receive public comment, and does, under the Administrative Procedure Act, receive public comment in rulemaking proceedings, but it's unheard of in an adjudicatory proceeding where you're trying to decide whether or not a particular party violated an FCC rule. And so it appears that the proceeding was opened and conducted in this way merely to put pressure on CBS, which has been the subject of continuing displeasure from the president in his social media posts. He has said that the FCC should take away their broadcast licenses, notwithstanding the fact that individual stations, not networks, are licensed by the FCC. And the commission has then linked its investigation of this news program with whether or not it will approve a merger between CBS's president, Paramount Global, and Skydance Media. And so it is jawboning in the worst sense, in a way that a unanimous Supreme Court said just last term violates the First Amendment. As I say, there's more to talk about than we have time. Those are just a few examples of the way in which the power of the FCC is being leveraged to put pressure on news organizations, and in particular, news organizations that seem to be displeasing to the administration.
Thank you, Bob. Yes, I'm realizing as well, this might need to be first in a series of discussions on free speech issues that we're facing today. But Professor Volokh, thank you for joining us, and please, the floor is yours.
Thank you. Thank you very much for having me. I have relatively little to add and virtually nothing to disagree with as to the preceding comments. I think this is generally quite correct. I think the administration is doing things that both would outright violate the First Amendment, and that even if they don't violate the First Amendment, certainly interfere with freedom of speech more broadly. So I'm trying to think what I can add. What I wanted to talk about is one particular facet of speech regulation that is not by any means the most important one, but one that hasn't drawn as much attention as is I think helpful, is necessary, and that is the logic of hostile environment harassment law. This is something I've been writing about for over 30 years, but has gained even more prominence recently with the attempts both by the Biden and the Trump administration to suppress what they view as anti-Semitic or anti-Israel speech on campuses, and also is being used at times as justification for certain anti-DEI laws on the theory that they create a hostile that certain DEI practices create hostile work environment or hostile educational environment based on race or sex or sexual orientation for whites, for men, for straight people, and the like. Hostile environment harassment law first emerged pretty much in the 70s and 80s as a gloss on, as a kind of an interpretation of anti-discrimination laws. Discrimination laws ban discrimination in terms and conditions of employment, and also, I oversimplify here, but very similarly apply to educational institutions and their students, to places of public accommodation and their patrons and the like. And they ban people from being, say, excluded based on race, on sex, sexual orientation, religion. Starting in the 70s and 80s, courts concluded that conduct that creates a hostile environment itself interferes with terms and conditions of employment. Sometimes talk about the psychological perks of employment. There was an early case, I believe the earliest hostile environment case involved I think an optometrist office that was racially segregated. Now, under federal Civil Rights Act, the ban on race discrimination in places of public accommodation applies to a very limited set of places of public accommodation, things like restaurants, hotels, places of public resort and amusement. Doesn't apply to medical practices and such. So there wasn't a federal challenge to be brought on behalf of the patients. But some of the employees said it creates a hostile environment for us as members of a group that is targeted for segregation to have to kind of work in this environment where the patients are segregated. And the court said yes, that's a hostile environment. It was later extended to so-called quid pro quo sexual harassment, basically sexual extortion, sleep with me or I'll fire you, and then to things like personal insults, usually race-based or sex-based insults. But the logic was that speech or conduct that creates a hostile or abusive or offensive environment in the workplace or an educational institution or a place of public accommodation or, in a few cases, housing, based on the anti-discrimination categories, race, sex, religion, sexual orientation. In some places, it could be veteran status or political affiliation and such, depending on what the state law categories the state law covers, is legally actionable. So long as it creates this environment for the plaintiff and for a reasonable person. So one began to see in the 80s and 90s cases where basically political speech or jokes or art or in some situations music videos that contained sexually suggestive content were seen as creating a hostile environment in the workplace for employees. And there basically the court allowed the case to go forward. Usually these kinds of cases eventually settle. It's very rare to have a trial, but when the court allows a case to go forward based on one of these things, it's essentially telling employers, look, you have to suppress this speech or else you'll face the possibility of massive liability. Just to give a couple of examples, to be sure, kind of rare examples, much of the time the cases get thrown out. These are not easy cases to win, but even a few denials of a motion to dismiss send the message, deliberately send the message to employers and, as we'll see, educational institutions and other places, that certain speech is potentially not damaging, but potentially dangerous for the employer to tolerate, and therefore the employer has to suppress it. So just to give a couple of examples, there were cases where people wearing clothing that had Confederate flags on them. The courts, or I think in these cases, perhaps the Equal Employment Opportunity Commission said that could create a hostile environment based on race because the flag conveys support for the Confederacy and that black employees might be offended. Certainly may be offended, but it is pretty clearly political speech that the law would then be suppressing based on its viewpoint. To give another example, I don't know how many of you folks remember the movie Downfall and all the memes that it generated. Downfall was a movie about the downfall of Nazi Germany, the last months of Nazi Germany. And there's a famous scene in which Hitler is ordering his generals to defend the country in the following ways. And the generals haltingly and kind of fearfully have to explain that, the armies that he is seeking to ask them to move have been destroyed. That Hitler's out of touch with just how badly things are going for him, and then he blows up at them. So the movie's in German. So there are all of these not even parodies, but little joke videos based on that, where I don't know, it's about some sports team, about how the coach is saying, oh, we should bring in this player. Well, I'm sorry, this player's been traded, or this player is long gone, or whatever else. So it's there were a lot of them, and one was played at a bank event. BNP Paribas, I think, was the bank, and it was a means of kind of mocking the competition, like the competitors are out of touch and they're trying to compete with us, and they don't realize how badly things are going for them. So in any case, a Jewish employee sued, saying this creates a hostile environment for him as a Jew because it depicts Hitler. Hitler, I'm pretty confident to say, is pretty hostile to Jews, but there's nothing in the videos that, as interpreted, actually, even the original video was not anti-Semitic. He wasn't complaining about Jews. He was complaining about losing. But I would think, as a Jew, I like movies about the downfall of the Nazis. But in any event, it was that was the complaint, and the court allowed the case to go forward. So, and if you think about it, it's not terribly surprising. Again, not all courts would do that, maybe not even most, but when you've got vague terms like hostile, abusive, offensive environment, for a plaintiff or reasonable person, it's got to be severe or pervasive. This is the kind of thing that happens. So I just wanted to give you a little bit of a big picture of the law. Here's how it plays out in practice. Starting with the Biden administration in 2024, the Department of Education was sending letters to various universities saying you're tolerating hostile environments for your Jewish students or for your Israeli students, because it bans, this applies to hostile environments based on national origin, which could cover Jewishness or could cover being from Israel. And some of the letters did indeed refer to alleged discrimination based on these statuses or targeted personal insults. But some of it, the assertion was that political statements of the kind of from the river to the sea variety, or death to Israel, or things like that, create a hostile environment. Again, perfectly possible to create a hostile environment, but it raises the First Amendment question of, can the government, through the threat of liability, demand the suppression of viewpoints, political viewpoints that are offensive to a particular group, sufficiently offensive to a particular group. Unsurprisingly, the Trump administration has continued with this, as have many private litigators. There's a recent case from Southern District of New York involving Cooper Union, which is a university in New York, University College, in any event. And the court there, I think quite correctly, said there are serious First Amendment problems with this, and I'm not going to allow the case to go forward based on kind of statements on matters of public concern, as opposed to personal insults or discriminatory attacks, which it could go forward on. Interestingly, a recent Harvard case from several months before, I think, erred as to the First Amendment. It did allow the claim to go forward. Likewise, some of the justifications for the Stop Woke Act in Florida and for some of the some lawsuits against diversity training programs run by employers, and I think for at least some arguments for just banning DEI programs, is that they create a hostile or offensive environment for white employees, because they talk about collective white guilt and generally are aimed at making white employees, the theory goes, feel bad about certain things in the process of then leading them to better treat their non-white coworkers. So that's on the employment side. The other stuff is on the university side. Of course, the two are often interact because every place is someone's workplace. Hostile employment law, as applied to universities or newspapers, may affect the contents of what is taught in universities and newspapers. So I just wanted to talk about that briefly, and let me just close with that and one other thing, or one broad point to be drawn from that and one other thing. So this is an example of a doctrine that was generally supported by, loosely speaking, the left. It's the one example where attempts to suppress supposed hate speech or bigoted speech have indeed been successful, even though some courts have recognized limits. But now, unsurprisingly, it's being used by the right in order to suppress anti-Israel speech, anti-Semitic speech. The left and the right, at least maybe used to agree with. It's hard to know. There are different groups in each category. So in any event, so that's just a reminder that attempts to restrict the speech of some will end up often being applied to different political polarity. Let me close with one other case, which sounds unrelated except for this one thing. Last year, the Supreme Court decided a case called the NRA v. Volokh. It just unanimously upheld or allowed the NRA proceed with its claim that the state government of New York was trying to suppress NRA advocacy by going after intermediaries, going after banks, going after insurance companies, and basically threatening them with retaliation unless they cut off or diminish their business with the NRA. And the Supreme Court said, yes, that is potentially a First Amendment problem. And that case is routinely now cited in the challenges here. So again, in case there was a victory for the NRA, is being cited against the Trump administration. But another thing that's interesting about that case is it was brought by the lawyers by lawyers who represented the NRA. The Brewer law firm did a very good job. They asked me to participate in the case of the cert petition, so I was counsel of record. When the court agreed to hear the case, I thought they would hire a prominent conservative lawyer to support them, or to argue, for them. Instead, they turned to David Cole, the national legal director of the ACLU. He's now a professor at Georgetown, or back to being a professor at Georgetown full time. He was at the time national legal director of the ACLU. And he argued, I think did a very good job. It was controversial within the ACLU. I believe the New York Civil Liberties Union spoke out quite sharply against it. But I think his view was, we've got to protect the NRA's rights if we want to protect the rights of other people who are more likely to be seen as our traditional clients. He was exactly correct. So I think both the harassment environment, hostile environment harassment example and the NRA v. Volokh example is just a reminder of the importance of protecting equally speech on both sides or all sides of political debates, precisely because the precedents end up being applied. Unsurprisingly, both speech protective and speech restrictive precedents being applied to all sides.
Great, thank you. First, before we get into questions, I wanted to give you each a chance to respond to the others. If somebody raised a point that you'd like to challenge, question, or add to, anyone? Keith?
I would just like to pick up on this last point that Eugene was making, and that is to say that when power is permitted in one area, it often has effects that blow back against your side. It's like Ira Glasser, former president of the ACLU, used to compare censorship to poison gas, which may seem like a reliable weapon for your side until the wind shifts. And so you see it becomes quite pernicious. And the point is to limit that power in the first place. Harkening back to what I was saying about the FCC and Chairman Carr, one of the things he has said in public interviews is that he is simply applying precedents that his predecessors in the Democratic Party had created while they were at the FCC. And to a certain extent, that is true. Some of these precedents were created during Democratic administrations. It overlooks the fact that in a previous Republican administration, that led to the demise of the Fairness Doctrine, which is really the progenitor of this news distortion policy. And you see examples of where folks on the left had tried to use the news distortion policy in the past to go after organizations like Fox News. Those complaints were quite properly dismissed, as these complaints against 60 Minutes should be. It's just that the principle is what limits parties of both sides in trying to use government power to restrict what news organizations and individuals too can say.
Thank you. Let me ask a couple of questions, and then we'll turn to some of the audience questions. We have quite a few. Keith, on free speech on campus, particularly, it's an issue you think about a lot. Can the government do anything to promote diversity of opinion or protect diversity of opinion on campus?
Well, I think there's a range of things that government can reasonably do in this space. I think the Trump administration has far outrun what can reasonably do, or is not using actually the tools that are most available and suited to them for this kind of purpose. So we might here separate out public universities from private universities. And so I think there's both important constitutional distinctions, but also some important principle distinctions between the two. I think state governments have a greater role in monitoring what happens in public universities and a greater interest in what happens in public universities. And they have more tools legitimately available to them to influence what happens in public universities. And among the things they might be concerned about relative to state universities is how politically diverse is the faculty, how are a range of viewpoints and opinions treated on the campus, and the like. I think there are some tools that are not very well suited for that, and some states have, I think, outrun what they ought to reasonably do in that space as well. But there are at least there's some activity that's not unreasonable for states to engage in relative to public universities. And we've sort of seen, for example, a lot of interest in a lot of states to create, or at least some red states, to create these so-called civic learning centers of various sorts at University of Florida, University of North Carolina, Ohio, Texas, range of places, kinds of centers to try to inject more faculty with a wider range of interest who are otherwise underrepresented on campus. And I think that's a useful thing for state governments to be doing that's compatible with the mission purposes of universities more generally. On the other hand, the Trump administration trying to leverage federal funds in order to tell Harvard and other private universities, you can get access to federal funds for scientific research. You can only do your cancer research, which we have an interest in trying to advance, if you remake your African American Studies department, your Women's Studies department, in order to have a more ideologically diverse set of faculty in that department. I might actually think that it wouldn't be a bad idea for Harvard to diversify the faculty at some of those programs and centers and departments in general. It's entirely inappropriate for the federal government to be trying to leverage its use of funds in order to try to influence the structuring of those research. On the other hand, we've seen, yeah. Go ahead.
So can you explain that really quickly for people who might not be familiar with some of the legal issues here? Because I think it has intuitive appeal when the government says, and people in the administration do say this, we're just deciding who we want to do business with. And the government's an actor in the economy and he can decide who it wants to do business with. There's no law being passed, nobody's rights are being suppressed. Why does that miss the mark?
Well, so I think there's a couple of issues here. So one is trying to think about what sometimes gets labeled sort of unconstitutional conditions under constitutional doctrine of even in cases in which the government, for example, gives funds to private actors or makes hiring decisions, for example, of its own employees. What kinds of extraneous considerations can it legitimately take into account when it's making those kind of decisions? And so we would recognize quite readily that while the government has a lot of authority to make decisions about who it wants to hire as police officers, for example, it can adopt a rule saying we're not hiring Catholics to be police officers, or we're not going to give grants to institutions that use Catholics as their science researchers on these grants and the like. It's an inappropriate string that the government might try to attach to its discretionary authority in that case. And likewise, we would say and the court has indicated that's true in the context of political opinions of various sorts as well, although there are some complications here and some real qualifications here. But I think, again, this is one of these areas where I think we would want to be very cautious to sort of open the door to allowing the federal government to leverage its use of resources to try to influence what kinds of political opinions to express more generally. Although, and here's where I would say there is, I think, a space here where even the federal government can operate, and previous Democratic administrations were extremely active in opening and working in that space, which is using grant money in order to try to positively make changes. So it's one thing to, I think, say, we're not going to give any money to Harvard University for its cancer research unless they hire some conservatives over in their African American Studies department, for example. It'd be another thing if the federal government were to create grants and say, we have an active interest in having more scholars studying subject matter X that we think is very important, and you can tap into those funds and make use of them if you hire scholars that will do research in this area. That is a way, I think, where federal government can have consequences for what kind of research and teaching gets done on a university campus through offering funds that are compatible with the federal government's own mission that private universities might choose voluntarily as to whether or not to pursue. And like I said, Democratic administrations in the past have made very aggressive use of this, and the Trump administration could be making more use of that particular tool.
Yeah, if I could just add one thing. I agree again with what Keith was saying. Just to give an illustration, folks may remember back not so long ago when various entities, mostly state entities, were trying to exclude Chick-fil-A from, let's say, airports or other transportation hubs that are run by the government. Because Chick-fil-A took particular views they didn't like on matters of sexual orientation. They may have had the right to exclude it for various other reasons. Sometimes they actually argued because it's closed on Sundays. It doesn't adequately serve our customers. There's only room for one place, and we need to have, or even only room for three places, and we all want them to always have three options and not just three options 6 days a week into the seventh. So if that's not a pretext, the government could say, we want to include some and others, or it might say, we don't really like chicken. We think our people don't like chicken. So we are going to have some other place because we think the food there is better. But if they say we don't want you because of your ideology, because of your political views that you express not in your restaurants but elsewhere, that is something that I think does violate the First Amendment, whether it's done by state or federal governments, and obviously it's done with regard to views of the left or the right.
Changing the focus just for a second a bit, Bob, can you, understanding we don't have much time, tell us a little bit about the Ann Seltzer case?
Yes, this is a case that was filed by then President-elect Trump shortly after the November election. He sued both Iowa pollster Ann Seltzer, our client, and the Des Moines Register and its parent company, Gannett, because of the publication of the Iowa poll shortly before the election that showed incorrectly that Kamala Harris at that time was leading by 3 points. As it turned out, Trump won Iowa by 13 points. So it was a real outlier poll. But that case is filed under Iowa consumer fraud law, claiming that this wasn't really a news item. Rather, this was a consumer product that the president can sue for being fraudulent. We're in the process of litigating that case right now, and so I guess just stay tuned. But happy to answer questions about that if you have them.
And everybody in the audience, please feel free to continue submitting questions. I'm afraid I will not get to all of them, but I will do my best to get to some of them. I don't know who this is best for, but was it just yesterday or the day before that the president suggested imposing a tariff on foreign films, in part because they push propaganda into our country? What do we make of that on First Amendment grounds?
There's a problem there. And it begins with taxation of speech as speech. There's a long tradition of Supreme Court decisions holding that taxation of the press is unconstitutional. There's the familiar precedent of Grosjean versus American Press, where Governor Huey Long, the Kingfisher, had imposed a tax in Louisiana on big city newspapers, which he called a tax on lying. And the Supreme Court, even as far back as 1936, held that that was an affront to the First Amendment. This proposed tariff it's a little hard to evaluate because there are so few details out there. All we really have is a social media post talking about them. But you're right in the way you posed the question, the fact that he isolated the reason for the tariff as being because these foreign films constitute propaganda. If that is the motivation, then it does have a significant First Amendment problem.
And I suppose maybe a more complicated question than that raises a bit is the situation with TikTok. And that's worthy a whole nother webinar, and perhaps we will do one. But perhaps the immediate question about TikTok is whether the president is just refusing to enforce a lawful statute passed by Congress. But part of the discussion about TikTok is also about foreign propaganda, isn't it? So how do we think about foreign propaganda and the First Amendment? I don't know if
so the analysis turns out to be really quite complicated. The case law is, there are cases that seem to set forth a clear rule in one direction or another, in one place or another. But if you step back and look at the big picture, they're quite a mix. So on the one hand, the court, for example, struck down in 1965 a federal law that required Americans who wanted to receive foreign communist propaganda, also as it happens there from communist China, that they had to specifically ask for it. It wouldn't be delivered to them through the mail unless specifically asked for it. And I said, well, wait, this challenger said, wait a minute, we don't really want to risk being put on a list of people who specifically ask for communist propaganda. That sounds like a very broad right to receive. To receive material from abroad and to send it to the U.S. possibly. On the other hand, the Supreme Court upheld restrictions on speech there to for designated foreign terrorist organizations in the Holder v. Humanitarian Law Project case. And the facts of the case are complicated, but the logic of it suggests that speech by foreign terrorist organizations also is something that Americans can't provide support for. So I do think that if, let's say, an American distributor wanted to distribute Hamas movies, Hamas is a foreign terrorist organization, I think they would be potentially facing federal prison for providing communications facilities to Hamas.
But again, as you point out, a much different situation. And a complicated factual situation, because here we have a range of issues. And it's a good example of where it would have, I think, paid for the Supreme Court to have stayed the case and waited to see how things developed.
It would have. But 9 justices thought otherwise.
No, I understand. I'm not trying to say that didn't happen. I'm saying it would have been preferable had they put it off, and you wouldn't have the separation of powers issue. The president unilaterally deciding, well, I'm not going to enforce that act of Congress for successive extension periods.
Certainly say that as a matter of free speech first principles, the TikTok case was wrongly decided. Or you can go with Justice Gorsuch that says the only possible justification for it is this concern about Chinese government using it for espionage and not for propaganda purposes.
Well, that's right. And the other point that Justice Gorsuch made was that it should have been reviewed under strict scrutiny and not under intermediate scrutiny.
He may well have been right. He did not draw any other votes on the court. So what I'm suggesting is that the rules with regard to speech by with foreign speakers actually end up being complicated and harder to predict than kind of free speech hawks like me. Usually I'm a free speech hawk, would like them to be. So I think the TikTok case fits in some measure within kind of the more restrictive side of that large and a pretty amorphous body of case law. Whether it may be wrong, and it may be that all the justices should have agreed with Justice Gorsuch or should have agreed with the challengers. I just think that this is not as simple a matter under current doctrine as TikTok wanted it to be. Obviously, it lost both 9-0 at the court. It lost 3-0 at the D.C. Circuit with a Reagan judge, a Trump judge, and an Obama judge, all very highly respected judges.
All true. That's all true. But we're not talking about a situation where someone was facing jail time for distributing foreign propaganda. We were talking about a forced divestiture of a social media platform. And it's really they focused on and minimized the First Amendment questions by saying that we're not talking about censoring speech. We're talking about the change.
I feel pretty confident that under the logic of Holder v. Humanitarian Law Project, if someone actually does business with Hamas and sets up a business relationship to distribute Hamas propaganda in the U.S., that would be covered by the law and not protected by the.
And if that had been the question in this case, I might agree with you.
And I'm sorry, in which case? In the TikTok
in,
case?
in the TikTok case.
No. Look, I'm not saying the TikTok case is controlled by Hoover Humanitarian Law Project.
Okay.
I'm saying if you look at TikTok, if you look at Hoover Humanitarian Law Project, various other cases, Kleindienst v. Mendel, which is a different fact pattern yet. But if you look at the big picture is that speech from foreign entities and in connection with foreign entities is less protected, I think, than some people might think. This having been said, I do think that just simply importing movies from France is, I think that is much further removed from any of these cases.
Yeah.
Well, clearly we need more webinars on this family of issues and maybe an entire one on TikTok. Let me wrap a few questions into one question and give you each a chance maybe to take a different piece of it to the extent you feel motivated. And the big question is sort of what is to be done, or what's the resistance or opposition here? And starting with first, how do we feel about the state of First Amendment jurisprudence and the courts on this? How is the administration going to do in the courts? Two, and Keith, I think, quite well pointed out that the courts can't fix all these problems. So two, what should we be looking for? Could we expect from other actors in government to push back on overreach by the executive here? And then three, what should regular citizens think about doing if they care about these issues? I would say first, of course, join the Society for the Rule of Law, perhaps throw a few dollars to us and a few others to fire. But otherwise, please. So what's give us an action plan or a hope for defending free speech in these times? Any piece of that any of you want to volunteer for?
Well, look, I think big picture, the government's going to lose some cases because it's been very aggressive and has pushed some boundaries that in areas where I think courts are going to be willing to step in. We may even see some situations where, because the administration has been so aggressive and it's pushed so hard, that the court is going to wind up drafting up new doctrine. And we may see that in the separation of powers context, for example. But we may also see this in the free speech context, where courts in other circumstances with different facts might have been a little more reluctant to go as aggressively against the administration. Whereas here, because of how the administration's behaved, we may see the court be a little more aggressive on some of these cases and wind up tightening up what governments can do in contexts in which they might have otherwise tolerated it. But we're also likely to see the administration win some of these cases, and they're going to be able to sustain some of their actions because courts are going to say this may be a bad idea, but nonetheless doesn't actually violate constitutional rules. And then what you're really relying on is to what degree then is civil society going to push back, or other politicians going to be pushing back. So far, we haven't seen much of that. So some of the questions going to start looking like, what does the midterm elections look like? Will Republicans eventually grow a spine in Congress when they realize that some of their own seats may be in question? It's not obvious that'll be the case, because a lot of members of Congress on the Republican side as well as Democratic side worry more about primary challengers than they worry about the general election at this point. And so that's not going to push them in this direction. So I think part of what we're seeing right now is courts are the only ones very willing to push back and seem very able to push back. And I've really been struck over the last several years, actually, is by the extent to which Congress has not been very effective in developing much of an opposition to administrative actions on these fronts.
Yeah, I agree with that, and I won't say anything about the politics of it because that's not my area of expertise. But I am optimistic about what's happening in the courts. We're already seeing a number of decisions that are cause for optimism. Judge Beryl Howell's decision in the Perkins-Coie executive order, for example, and the decision in the Associated Press case, and so on. And I think if you track the range of litigation over these executive orders, the government's win rate is much lower than usual. And I think the reason for that is because this administration has decided to push so many boundaries and to question a number of norms, both in civil society, but also judicial norms. And so that's one of the reasons why I think that the system really will hold. I don't like describing what we do as the resistance because I don't see it that way. I don't see it as really any different from what we were doing during the Biden administration or before that during the Obama administration or the first Trump administration. It's really where the government exceeds its boundaries. We push back on it because the principle of protecting the First Amendment and a culture of free expression doesn't change. It's just the actions of different administrations do.
Professor Volokh, did you have anything to add to that?
Yeah, I agree with pretty much everything that my colleagues have said. Let me just highlight one important point, especially for non-lawyers in the audience. The district court decisions, I think, on balance, have been quite good and have properly vindicated free speech rights. May agree or disagree with a few details, but on balance, that's so. District court decisions are just decisions of one judge, often a judge who is in some measure selected, usually by the selection of the district in which the claim is filed, by the plaintiffs with an eye towards getting a judge who agrees with them. Perfectly legitimate behavior by lawyers. In fact, it's what we pay them the big bucks for. But at the same time, it's just a reminder that a district court decision may not represent the views of higher level judges, for example, in the appellate courts or eventually the Supreme Court. So I think before we count our chickens, or before the other side counts its chickens, it would be useful to see what happens on appeal. Now, the Supreme Court, of course, nobody's entitled to their day in the Supreme Court. So it may be that a lot of these cases will just end up at the Court of Appeals. But the one litigant that tends to get the ear of the Supreme Court when it asks for review is the federal government. So I think a lot of these cases are going to end up in the Supreme Court if the federal government thinks it loses below and thinks it's good to try with the Supreme Court. So I think we'll know more within a few years about this. But we should neither be unduly dispirited nor unduly encouraged by decisions of district courts.
Thank you. I think that last question pretty well serves as concluding remarks, and we are at the hour, but I'm happy to offer anybody the opportunity to add some closing thoughts that they might have had.
Well, just very briefly, I would say that one of the reasons why I'm optimistic is that the health of the First Amendment has been defined by periods of crisis. We saw this with the period of censorship under Anthony Comstock that went on for 40 years, during the first Red Scare and the World War I era prosecutions, the McCarthy era, what happened under Nixon. All of those events, some of which described as constitutional crises, led to a stronger body of First Amendment law and protections for freedom of speech. And I don't expect this to be any different. I take Eugene's point that we have to wait to see what the courts at higher levels need to do, but I see nothing in what's going on so far to make me pessimistic about being able to use those tools to preserve the system that we have.
So I might just go back briefly to something that came up in the opening statements from Bob and Eugene, which is we've seen speech restrictions in the past from one side of the aisle where they're often sort of assuming this is only going to work in my favor and will never come back to bite me. And one thing I think we've seen people on the right say is we need to make sure that this goes back and bites people. And the scary version of this is we're just in a downward spiral. That we get both sides increasingly looking for tools to hit the other side with, and we don't recover from it. We can't pull out of it very well. The more optimistic version is everybody learns their lesson, realizes this was all just a terrible idea, and we need to retreat to a more robust set of liberal principles in the future and be more protective about these things so far. I don't know which way this is likely to play out. I'm not very encouraged by how it's going so far. But I know that I think that the attitude of some certainly has been the other side needs to feel the pinch. And when they feel the pinch, they will realize we should stop doing this. And so, maybe there's a possibility of optimism that everyone will learn their lesson here and will retreat to a better equilibrium down the road.
Yeah, so that's just such an excellent point. And it's just a reminder that the question is, what lesson will they learn? Is it, well, we should all disarm, bilaterally disarm in the war against speech and protect other people's speech? Or is the lesson, well, the only thing to do is when one side restricts your speech, you double restrict them when you're in power, and then they redouble again. Human nature being what it is, it's hard to know that things will work out the optimistic way. But there's always hope.
Well, it's great to close with a dose of optimism and a word of caution and the need for resolve. We are truly privileged to have all three of you here today. I mean, I think many in our audience know, but for those who don't, these three are among the nation's leading experts on this issue, and that they would be so generous with their time to talk with me and with our membership. We can't thank you enough. So thank you all. This video will be uploaded to our YouTube channel. So if you missed a part, you can come back to it, share with friends. Membership, again, is what makes our programming possible. So please consider becoming a member or encouraging your friends and family to do so. Follow us for updates on YouTube, Twitter, Blue Sky, and LinkedIn. And with that, just a few minutes over, I will close our conversation. Thank you, gentlemen, so much, and have a wonderful afternoon.
Thank you.
Thank you.